Okay, let's see. Sir, are you Trevor Pinkelman?
Yes, sir.
Okay, and then we have Mr. Mehmet on behalf of the plaintiff. So we'll go on the record. This is case number 2319476, Michigan Schools and Government versus Trevor Pinkelman. And this is set for a status conference in this case today. Although just looking through the file, I see Mr. Memo, you did file a motion for summary disposition that's noticed for hearing next month in June. Is that correct?
Yes, Judge. We haven't received the notice of it, but I know it was filed. Yes.
Okay. So I guess my suggestion would be rather than setting any further dates to go forward today, to have the hearing on that motion and then see which way that goes and then go from there. Mr. Memo, do you have any objection to that?
No, Judge, I think that'd be prudent. We've already conducted discovery, so I think we're just good to
Okay.
go for that motion. The defendant has time to respond. So,
All right, Mr. Pickleman, do you have any objection to that?
I guess I don't really fully understand what that means.
So on behalf of his client, Mr. Mehmet filed a motion. It's called a motion for summary disposition, and that's set for hearing in June. And if you haven't received a copy of that yet, you should be receiving it. And so all I'm saying is the court wants to hear that motion and decide on that motion before we schedule anything further in this case today.
I guess I don't. I'm working with Miss Larissa Waltman on filing for bankruptcy. I'm not trying to waste anybody's time here. So I just wanted to make that aware that that's what I am doing and the route that I'm going with. I don't know if that changes anything in a further case here or what have you, but I just was the only option I have left to do.
All right, well, you might want to have Ms. Waltman contact Mr. Mehmet so that they can talk about how that may impact this case and where that is at.
Okay.
But otherwise, the next court date in this case will be June, and I believe it's June 3rd is the date set for the motion hearing. But either way, Mr. Pickleman, you'll get a notice of the hearing on that. So that's your next court date in this case.
Okay. All right. Thank you, sir.
Okay. All right. Thank you. That's all for today. And all parties in this case are free to disconnect at this time.
all
All right.
right.
Bye-bye.
Thank you, Judge. Have a great day.
Thank you. Okay, Mr. Rolla, are you able to hear me okay?
Yes, Judge, can you hear me?
Yes, thank you. All right, we're on the record now in People versus Ralph Edwin Kronk Jr. Two files, case number 952035 and 952036. Both of these were set for hearing today on motions to set aside convictions. They were set for hearing at 1:45. It's now 1:48. I do not see Mr. Kronk in the Zoom waiting room. Mr. Rolla has appeared on behalf of the people. So with Mr. Kronk not appearing today, Mr. Rolla, my view would be to just simply dismiss these applications. If Mr. Kronk wants to renotice them for hearing, he's free to do that, but I'm not going to take further action. Do people take any position?
Judge, I think that'd be the only thing you actually can do since he's bringing the motion. And as the court's well aware, in order to proceed, he has to be present, whether that's in person or as the court would allow, in this case, via Zoom.
Okay, so the court will simply dismiss the hearings, adjourn these matters out, and the court will not set any future dates unless and until Mr. Kronk contacts the court and asks the court to reschedule. So that's all. Thank you, Mr. Rolla. You're free to disconnect.
All right, thank you, Judge.
Okay, sir, are you, Andrew, Lair? I'm sorry, could you repeat that?
Can you hear me now?
Yes. How do you pronounce your last name?
Lair.
Lair, okay. And Miss Lair, are you there? Can you hear me?
Yes, I can.
Okay, all right, we're on the record now in Lair versus Lair. This is case number 24-19565. The record should reflect both parties are present today by Zoom video. I have this set today as potential entry of a judgment of divorce. Ms. Lair, is that how you wanted to proceed today?
Yes, I believe so.
All right, and Mr. Lair, is that how you want to proceed as well?
Yes, sir.
Okay, so I'm going to place both of you under oath, and then I'm going to ask each of you a series of questions. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you could both raise your right hand, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes.
Thank you. You can both lower your hand. Ms. Lair, my questions are going to start with you. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you filed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, it was.
Does that remain true today?
Yes, it does.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
Nope.
Under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. Is that correct?
Correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
All right, and under the judgment, it it indicates that each of you have divided up your own personal property between the two of you, that there don't remain any debts to be divided, and that each of you would be responsible for any debts that are in your own name. Is that correct?
Correct.
And that you don't own any real estate or real property together. Is that correct?
Correct.
Okay, and then Miss Lair, you're asking to have your last name changed to Roos. Is that correct?
Yes.
Okay. All right, Mr. Lair, have you heard all the questions that I've asked Miss Lair?
Yes, sir.
Have you heard all of her answers?
Yes, sir.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
Under the judgment, Mr. Lair, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, sir.
And do you agree that all property has been divided up, that there don't remain any debts that need to be divided, and that each of you would be responsible for any debt that's in your own names?
Yes, I agree.
And do you agree that you don't own any real estate or real property together?
Yes.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will sign the judgment with today's date. That means effective today, your divorce is final. So Ms. Lair, that means that your last name will be legally changed going forward from today. So you will need to change your identification and other documents to reflect that.
Okay.
Do you have any questions, Ms. Lair, at all?
I don't think so. Well, I guess, will we get a divorce decree then in the mail? Or do I have to come pick one up, or how does that work?
I will mail you one in the mail.
Oh, okay.
Okay.
All right, thank you. Mr. Lair, do you have any questions?
No, sir.
Okay, thank you. That's all for today, and both parties are free to disconnect at this time.
Thank you.
Have a good day.
Thank you. All right, court's next hearing is set for 2:45, so we'll be in recess until that time. Okay. Excuse me. It looks like we have everybody connected, so let's go on the record now in Core Energy versus DCP. This is case number 19-18001. And if I could have counsel unmute yourselves, and starting with plaintiff, just put your appearances on, please.
Good afternoon, Your Honor. Tom McCarthy appearing on behalf of Plaintiff Core Energy.
Good afternoon, Your Honor. Daniel Quick appearing on behalf of DCP.
And I'm here on a different matter, Your Honor. I'm here on the 3 o'clock pretrial for Walter Drzwecki.
Mr. McBride, sorry about that.
That's okay.
I will put you back in the waiting room for a minute.
All right, thanks.
Okay, counsel, we're on the record here today for a status conference. Just looking at the file, it looks like some dates were extended out, and I believe recently expired. So just wanted to see where things are at and where we may need to go with scheduling going forward. So Mr. McCarthy, on behalf of plaintiffs, where are you guys at?
Thank you, Your Honor. As the court will recall, there was companion litigation involving Riverside that your colleague Judge Hunter had. That became quite involved. The good news is that that case has been settled. As a consequence of that, the facility that Core owns, the compression facility, which is right next door to Mr. Quick's client, on January 1 of 2025, Riverside will be acquiring that facility. So we're very close to my client no longer having ownership of that facility. So what we would ask the court to do, and as a result of that, the issues that have been raised in the pleadings, we don't think it is useful or necessary for the court to spend its time wrestling those to the ground, because in 8 months, my client will no longer be the owner of that facility. I've disclosed this to Mr. Quick. He understands this. I also believe, but don't know, Mr. Quick might be able to address this, that Riverside is having direct discussions with DCP about perhaps building its own facility and connecting to the DC piping. So the bottom line is my client on its way out, Riverside steps in the shoes of my client for purposes of acquiring that facility in January 1 of 2025. And separate and apart from that, I think Riverside is engaged in transactions with DCP to accomplish something that we're not privy to. So we would ask the court to consider just maintaining the status quo, setting this case for another status conference the first week of January, at which point either dismiss the case, or if Riverside is so inclined, have Riverside substitute in, because at that point, Core will no longer be a proper party in interest.
All right, thank you. Mr. Quick, what's your view on this?
Well, I can give you the short version or the long version, depending on what your reaction is to counsel's proposal.
Okay. Well, I mean, I can tell you, Mr. McCarthy, I appreciate the position that you're taking, but you know, from the court standpoint, I'm not really in a position to just not do anything with this case for 8 months, and you know, wait to see what happens in January. So, you know, the court has an interest in moving its docket, and this case is already 5 years old and only getting older with no progress. I mean, I guess I say all that to say is something's going to have to happen before January, whether that's by motion practice or a settlement of the parties, but I'm unlikely to just push this out that far with nothing happening. So with that in mind, Mr. Quick,
That's helpful. Thank you, Your Honor. A little bit of history just to help inform the court's understanding of the moving pieces here. So, and you may recall some of this, although we haven't been in front of you in a bit. Riverside is a substantial customer of DCP. So it obtains gas from out in the fields and supplies it to DCP for processing. So the fact that Riverside has acquired the core facility, so it's both our customer on the front end and now with stepping into the shoes of being our adversary, so to speak, on the back end to the extent it inherits core's claim, creates an interesting business situation for the client. And I have, since we caught wind of this earlier this year, and Mr. McCarthy, I hope will confirm this. I have continued to express to Mr. McCarthy that, of course, we had a scheduling order and there was still a substantial amount of discovery to be done. We had done a significant portion of it, but we had a number of both document disputes brewing as well as needing to accomplish additional depositions. And Mr. McCarthy was I'll use the word hesitant, if perhaps a stronger word is appropriate, to engage in that further discovery given these developments. And so the short version of this is that it is, and then I attempted some settlement discussions with Mr. McCarthy. Those haven't gone anywhere. And so it certainly may well be the case that when we get to January and Riverside via some mechanism owns this facility, that before then or at that time, the parties will have come to some sort of agreement which resolves this matter because of the change in dynamics, if you will. But it is also the case that we can't simply dismiss it because the parties have invested and the court has invested a lot of time and effort into it, and we're not willing just to shelve the issues raised in the counterclaim in particular. So if we are to continue on, I have, in reliance upon Mr. McCarthy's express commitments with regard to his consent to extensions, not engaged in the rest of the heavy lifting that would be necessary to bring discovery to a close. So if the court's direction is that we would, that you'd like to see us proceed, close it out, file dispositive motions, and move forward as we would in any kind of regular case, then I would certainly ask the court to grant us an additional window so that we can complete that discovery, file those dispositive motions, et cetera. On the other hand, given where we are and the fact that it is May, I'm not sure that my client, I know that my client wouldn't necessarily oppose Mr. McCarthy's request, although I'm obviously aware of and sensitive of the court's docket management requirements with SCAO, et cetera.
Okay. Anything further that, given what we've just discussed, Mr. McCarthy, since you went first, anything you want to respond to or indicate from your side?
Your Honor, I would respectfully ask the court to consider entering some sort of a stay, maybe a formal stay if that fits better with the court's view of what we should do. I hear in Mr. Quick's comments that his client would not be opposed to that. It just strikes me that it makes little sense for us to pick up with our discovery disputes and file motions to compel before Your Honor and other motions when the landscape really has changed and the interest of the parties have changed. And I think DCP and Riverside are in the process of figuring out what's next for them as CORE passes the baton to Riverside. So I appreciate on one hand, the court doesn't want to just let this case languish forever. On the other hand, respectfully, it makes no sense for the court to spend its time meting out rulings on discovery disputes, which we would have because when we ended up we had discovery disputes, and then motions and the like. So I guess that's a long way of asking, if the parties are in agreement on a stay, does that make it easier for you?
Yeah, I guess maybe can you just, I just want to understand a little bit better about this potential sale by Core to Riverside. You know, I mean, what's stopping Core from just dismissing it now? I'm assuming that the concern is that if that deal doesn't go through somehow, Core doesn't want to have to restart all the litigation. I mean, is that just it, or is there something else at play?
Well, actually, the agreement with Riverside has been finalized. So this isn't, they're having discussions with Riverside and it might come to fruition. It has come to fruition. And what will happen on January 1 is a fait accompli. It will happen. So I suppose the other thing we could do is both sides could dismiss their claims. I think it ought to happen without prejudice. Both sides dismiss their claims without prejudice, without costs, and the case goes away. And the reason I say without prejudice is I don't want Riverside to come in and be critical of what Core has done in terms of reaching agreement. I think the principal folks to decide what happens next really are Mr. Quick's client, DCP, and Riverside. So we're quite certain, because documents have been signed, that on January 1, the ownership, I mean, documents have been signed and are being held in escrow. So it's not a matter of maybe this will happen. This will happen, and the parties are planning for it. And I'm sure that, I mean, I suspect that Riverside is having discussions with DCP now in anticipation of that. So it just strikes me, Your Honor, that it would be hugely inefficient in terms of judicial resources and economy and cost to the parties for us to start taking depositions and fighting about issues that, frankly, the landscape has changed and people feel differently about them.
Okay, all right. So I think based on what I'm hearing from both of you, I guess what the court would be looking for is some kind of stipulation or agreement between the parties to hold off until January 1st. I think if I've got both sides agreeing that in this case, based on the particular nuances and developments in this case, that's the best option. From what you're telling me, I don't necessarily disagree. I mean, it makes some sense to me. From my docket management standpoint, I mean, on one hand, yeah, we want to keep it moving. On the other hand, it is 5 years old. So, you know, to the extent the court is running afoul of guidelines, it's run afoul of those guidelines a long time ago, I guess. So I don't want to, you know, miss the forest for the trees here and insist on actions by the parties, which are going to result in expense to them and court time, when really the most sensible thing is to wait. So in essence, I think you guys have sold me that is a prudent course of action here today, assuming that both parties can agree on it. And so, Mr. Quick, I know you said that your client wasn't necessarily objecting to it. That's different than stipulating to it. So where are you with that?
Well, if the court was going to stick with its initial inclination and reject Mr. McCarthy's proposal, then DCP is not open to dismissal for a couple different reasons. And so then would be prepared to move forward to complete discovery, move forward. But I think under the circumstances, given the opposition of the plaintiff, that waiting until January does make sense, and we'll certainly continue to try to resolve things behind the scenes in the interim.
Okay, so then I'm just going to ask counsel to prepare a stipulation order that reflects that the court is going to postpone further scheduling in this matter pending the sale of core to Riverside. And that the court will set this for a status conference at its next available date following January 1st.
Very well,
Thank you
Your
for
Honor.
your patience, Your Honor. Appreciate
Yeah,
it.
thank you for your patience and your understanding. I'll be happy to take a crack at that stipulation and send it to Mr. Quick, and we will get it to Your Honor.
Okay, thanks. And then once we have that and I've signed it, my office will send out a notice of date and time of that next status conference.
Very well.
Okay, thank you. That's all for today. And you're both free to disconnect at this time.
Thank you, Your Honor.
Thank you.
Okay, we both got both counsel connected, so we'll go on the record. This is Dravecki versus Progressive, case number 2419607. If I could just have both counsel put your appearances on, starting with plaintiff, please.
Yes, good afternoon. Josh McFarland appearing on behalf of plaintiff.
And Daniel Collison appearing on behalf of defendant.
All right, thank you. We're on the record here today for purposes of a scheduling conference in this case. Mr. McFarland, I did have a chance to just review the complaint. This is an underinsured motorist claim, is that correct?
That's correct, Your Honor.
Okay. Are there any kind of special aspects of this case that are going to require, something out of the ordinary in terms of scheduling? Anything that you can foresee in that regard?
I don't think so. I think the only thing I might be able to foresee would be the maybe possibly locating the tortfeasor if his deposition is required or if his appearance is required at trial. That may be the only thing that I can think of, but other than that, it seems pretty straightforward.
Yeah, this accident happened in Kentucky, Your Honor. So we gotta track him down over there, I guess.
Yeah.
Okay. Mr. Collison, from your side, other than what Mr. McFarland indicated, anything that you can foresee in terms of issues that are going to require some kind of special scheduling?
I don't think so. We just got a lot of medical to get a hold of and, some depositions. So it's pretty
All right.
ordinary, I guess.
Okay. So I guess what I would suggest is let's set aside a period for discovery and some mediation. And then typically what I do is set it for a status conference at the close of that period and then see where everybody's at. So in terms of discovery, how much time would you guys like for that?
What do you think, Josh?
I always love being put on the ball. I always ask for 180 days if the court will give it to us. Otherwise, like 150 days, something like that. Just I don't like to come back to the court and ask for more time. Is what I try to avoid.
Yeah, my typical request is 180 as well.
Okay. I don't have any objection to that. So we'll set aside 180 days for discovery. The court typically orders mediation to occur within that period of time. Do either of you have any objection to that?
None here. No. As a matter of
Okay.
fact, Judge, I don't know how you handle it, but I've been doing a lot of opting out of case eval and going strictly with the mediation. But that's totally up to, I guess, Josh and you.
Typically from the outset, I order mediation first,
Right.
and then discuss case eval later because a lot of parties are electing to opt out of that. Any objection to a dispositive motion cut off 30 days after the close of discovery?
No.
No.
All right, and then like I said, what I'll do is set this for a status conference at about the time of that dispositive motion cutoff. If there haven't been any motions filed, that gives us the next date to meet and see where the case is at. Obviously, if the case settles before then, we won't need that. And then I also use that status conference to conduct further scheduling if it looks like the trial, the case is headed towards a trial track. Mr. McFarland, any other dates that I can address for your side today?
No, Your Honor, thank you.
Mr. Collison?
Do you typically give a deadline for witness and exhibit list? Or do you just leave it open?
I usually don't, but if the parties want me to address it, I have no trouble setting that if you guys would like me to put some dates out there for that.
You know, I really don't need a date other than if we're actually going to trial, I'd kind of like to know who the witnesses are going to be so that properly prepared. But other than that.
Right, and if it does look like it's headed towards trial, then I certainly do set deadlines for witness and exhibit lists and those types of things.
Okay. Beautiful.
Okay.
Is all your snow gone up there yet?
Yeah, this year it's been gone for quite a while. It's not unheard of to still have some snowbanks in the shadows at this time of year, but this year we're lucky we don't. So.
Well, I actually was just through there not long ago. I was up in Petoskey for some depositions, and I was surprised there was no snow anywhere. I never even saw any in the woods. So.
The trees are starting to bud, which is probably a good 2 weeks early. So yeah, we're enjoying having an actual spring this year.
Well, enjoy it while
Okay.
you can.
I will put all these dates into an order and get that out to you, as well as a notice of the date and time for that next status conference near the close of discovery. And you're both free to disconnect. Thank you.
Thank you, Judge.
Thanks.
Okay, Mr. Slough, are you able to hear me okay?
I can hear you just fine. Good afternoon.
Okay, good afternoon. I think Mr. Blumberg's connecting right now, so it may just be a minute here.
Judge, I got a note about a half hour ago from Mr. Blumberg's office that he had a scheduling conflict today that occurred, and he wasn't aware of the hearing. I think his client was planning on appearing from his office,
Okay.
but that he was not. So I just want to make you aware of that.
All right, sir, are you Mr. Trevor?
I am.
Okay. All right, well, I can't really proceed today, obviously, without Mr. Blumberg present, so, Mr. Slough, do you want to renotice your motion? What's
Well,
your view?
I guess I would just suggest to the court. I mean, I did properly serve it. I don't. You know, I think it was just an oversight by Mr. Blumberg's office. He did not file a response to it. And I would suggest that really I'm just offering an affidavit and documentation to support, you know, the prior arguments at the summary disposition hearing. It's really in the court's discretion of whether it wants to receive that. So, you know, I'd prefer to not delay the court's decision on the summary disposition motion, and just leave it to the discretion of the court whether it wants to consider that additional information. I think it's relevant. I don't know how material it is to your decision, but it's something that we felt we needed to at least provide you.
All right, well, I guess, you know, it's an unusual situation. Typically, you know, just out of courtesy, Mr. Blumberg obviously practices in front of the court. Often, he's rarely misses a hearing. And so, you know, I think the court's in the position where, you know, certainly if the roles were reversed, the court would grant some leeway to your side, Mr. Slough, of course. So I guess what I'm going to do, Mr. Slough, is have you talked to Mr. Blumberg about whether or not he would stipulate to this if the court allowed his side to submit? You know, I mean, I think even if I granted your motion, I would have to give Mr. Blumberg an opportunity to submit additional documentation to counter whatever you submitted as well, because he's got an obligation.
Yeah, he certainly had an opportunity to respond to the motion, and I mean, I filed this over a month ago, so I mean, well, excuse me, almost a month ago. So I mean, I think he's had adequate time for a response. I certainly appreciate the court's, you know, deference to wanting to give Mr. Blumberg an opportunity to appear, and I will certainly reach out to him about potentially stipulating. I was kind of surprised, candidly, that I didn't hear from him about maybe just stipulating to allowing it in. But I'm certainly willing to do that, to speak with him about just a stipulation. If the court wants to set it for another hearing, I'm happy to notice that up. What I don't want to do is continue to delay, you know, a decision on the summary disposition motion, because it just kind of leaves everything in limbo.
All right,
but if we
here's
have
what I'm going to. Sure. Okay. Here's what the court's going to do. The court's going to allow for 7 days for the parties to submit a stipulation. If no stipulation is submitted, then the court is going to rule on the motion either on its merits or set it for a hearing. And as part of that, the court will also determine whether it can rule on the motion for summary disposition. So in other words, I'm going to give the party 7 days to decide whether they want to agree to this. If not, the court will issue a ruling about whether it's going to allow the affidavit to be considered, or whether it's going to require further hearing on that so Mr. Blumberg can be present. And then depending on that ruling, the court may or may not provide its full ruling on the motion for summary disposition.
Yeah, and if I may, Judge, just maybe in that order as well, give Mr. Blumberg 7 days if he wants to file a response or provide some other rebuttal. I'm totally fine with that.
All right, and I think that's fair, and I will include that as well. So I will put that into an order and get that out today.
All right, very good. You don't need me to prepare anything then?
No.
Okay.
I don't want you to try and have to write down what I just said.
Okay, appreciate that.
Okay, thank you. That's all for today. And the court will note for the record that Mr. Trevor was present, although his counsel wasn't able to be. And all parties are free to disconnect at this time.
Okay, thank you.
All right, and that includes the court's YouTube docket for the day. Court will be in recess until